Next, we'd like to ask Mr. Katsura Masanori, Director General, Trial and Appeal Department, Japan Patent Office, to take the floor to speak about the current state of trials and appeals in Japan. Thank you very much for your introduction. I am Katsura, Director General of the Trial and Appeal Department at the Japan Patent Office. I'd like to take the next 20 minutes or so to introduce the latest status of trials and appeals at the JPO. I am currently speaking from the auditorium of the JFBI Hall Clio in Kasumigaseki, Tokyo. Unfortunately, the weather is rainy and the temperature is getting much cooler, and it really feels like autumn in Tokyo. How are all of you who are participating online doing? All the speakers in this room, including myself, will be wearing masks to prevent COVID infection. So please bear with us. We ask for your understanding in this regard. Now, please stay with me for about 20 minutes or maybe less. First is the role of trials and appeals and handling of procedures affected by COVID-19 within the JPO. Broadly, there are two functions of trials and appeals: reviewing examinations and early resolution of disputes. To exercise examination reviewing function, there are appeal against an examiner's decision of refusal to determine the validity of the examination results and a position to improve the credibility of the right. As for the early resolution of disputes, there are trials for invalidation to determine the validity of rights, such as those related patents, trials for correction to correct the scope of patent claims, trials for rescission of trademark registration to cancel the registration of unused trademarks, and Hantei advisory opinion to provide expert opinion regarding the scope of rights. In order to fulfill these functions of examination review and early resolution of disputes, the Trial and Appeal Department, or TAD, plays a role equivalent to that of a court of first instance. The TAD conducts proceedings in accordance with the strict procedures and quasi-judicial proceedings prescribed by the Code of Civil Procedure. It is essential for the TAD to issue a decision promptly and accurately in fulfilling its review and dispute resolution functions. For this reason, we set a target pendency for each type of trial and appeal and work to render a decision within a certain period. For example, in the case of patent appeals against examiner's decision of refusal, we try to issue a trial decision within 9 to 11 months after the completion of the formality check. And in the case of trademark oppositions, we try to issue a decision within 5 to 7 months after the completion of the formality check. In the last fiscal year, even with COVID pandemic, we were able to achieve all of these target pendency thanks to your support. We will continue to make utmost efforts to achieve the target in this fiscal year and onward. Next, I'd like to introduce the trend of requests for various types of trials and appeals. The graph on the left shows the number of requests for appeals against examiner's decision of refusal, and on the right is the number of requests for invalidation trials. As you can see, compared to the year before last, the number of requests for various types of trials and appeals did not decrease last year despite COVID-19, and in fact, some of them increased. The number of requests for appeals against examiner's decision of refusal for patents has been decreasing since 2015 due to the expediting of patent examinations. So that resulted in the number of the decisions. So that was behind this decrease. But there has been no significant changes in the rate of requests for appeals. the number of patent invalidation trials has decreased since 2016, when the opposition system was introduced. So some of the numbers went into this opposition system. So that's the reason why it was decreased. The graph on the left shows the number of opposition filed, and the graph on the right shows the number of requests for trial for trademark rescission. In addition, the number of claims has not decreased despite COVID and has generally remained unchanged. The Japan Patent Office is actively promoting telework so that each trial case can be examined quickly and accurately even during the pandemic. For example, even if all these 3 administrative judges of the panel are unable to come to work, proceedings will be conducted online and conduct prior art search when deemed necessary. The panel drafts, trials, and appeal decisions are done, and also the drafting can be done online. The panel proactively conducts online interviews when interviews are considered necessary. We had not taken any such action before the spread of COVID-19, but since last spring, we have made a significant step in a very short while in our efforts to ensure prompt and accurate proceedings. In the past, it was necessary for the applicants to appear in person for oral hearings for invalidation and other trials, but the law has now been amended to allow appearance online in order to cope with this COVID situation. Although the amendment to the law just came into effect on October 1st, online appearances have already been made in several oral hearings, and we have heard that the proceedings have been quite smooth. It is also possible for some to appear online and for the rest to appear physically. So this it applies to both defendants and plaintiffs. I think that online appearances will be used in many oral hearings in the future. In addition, the law has been amended to eliminate the need for a non-exclusive licensee's consent when correcting or abandoning a patent right. In the case where there are many non-exclusive licensees, it was practically difficult to obtain the consent of all of them, so that this amendment was carried out. The effective date of this amendment is April 1st, 2022. Please note that the consent of the non-exclusive licensees will no longer be required after April 1st next year.
Next, I'll explain about the globalization of IP disputes. IoT is penetrating into all industries and various aspects of our daily lives. This has led to a significant increase in the number of related standard essential patents, SEPs. For example, the number of patents declared essential to ETSI, the European Telecommunications Standards Institute, is 5 times larger for 5G than for LTE or 4G, so it's expanding at a phenomenal rate. Under such circumstances, license negotiations and disputes over standard essential patents are also undergoing significant changes. In the past, disputes were mainly between parties in the IT industry, so it was possible to resolve them by cross-licensing. The two parties generally agreed on the market rate of license fees, and it was relatively easy for the parties to evaluate and judge the essentiality of standards. However, with the current penetration of IoT, disputes over standard essential patents are arising between different industries, and in such cases, it is difficult to resolve them through cross-licensing, and the two parties have very different views on the market rate of license fees, making it difficult for the licensee to evaluate the essentiality of standards. This slide shows major disputes, that is, lawsuits and administrative actions over standard essential patents around the world. Disputes between or amongst the different industries are shown in red. Although individual cases are not shown, trials for invalidation for standard essential patents have been filed in each region with the rise of disputes over standard essential patents. This undoubtedly shows that the trial system plays a role in resolving disputes over standard essential patents, and it is also proof that the trial system is becoming increasingly important. Now to sidetrack a little bit, in Japan, in patent infringement lawsuits, the accused party can mount a defense by filing for patent invalidation, and the court will also make a decision on the invalidation defense. So it is possible to file for an invalidity trial at the JPO alongside the infringement suit. So you have these two routes over the validity of the patents. This is called the double-track system. In this double-track system, the trial and appeal department at the JPO strives to issue trial decisions on invalidation as early as possible, since that then can be considered by the court. In this way, the JPO is making a contribution to dispute resolution. Here, I would like to introduce some data on the analysis of the results of the double tracking. Right-hand side chart, please. As you see in this pie chart, in approximately 88% of the cases, the trial decision was issued before the district court decision. And the pie chart on the left, the blue part, the percentage of agreement between the invalidation trial and the infringement suit was 75%. From this kind of data, you can see that by issuing decisions for invalidation trials early, the courts and the JPO are practically working together to resolve disputes. Returning to the topic of standard essential patents, the Trial and Appeal Division also provides a service to make judgments on standard essentiality in the judgment system, in the Hante system. From here, I introduce the international activities of the Trial and Appeals Department. To facilitate overseas users' understanding of the Japanese trial and appeal system, we are actively publishing information in English. The Handbook for Trial and Appeal System in Japan in English explains the Japanese system in general as simple and to the point as possible. We hope you'll take a look. We also provide English translations of trial and appeal decisions and other documents. In the last fiscal year, we provided 100 English translations of trial decisions and other documents deemed to be helpful for understanding the interpretation and practice of the law at the TAD. We plan to provide about the same number of English translations this fiscal year as well. We're also actively conducting international exchange in the field of trial and appeals. In June of this year, we held the IP5 Trial and Appeal Board's high-level meeting. In addition, we continue to hold regular meetings and exchange opinions with IP offices in various countries and regions. Furthermore, this symposium, the Judicial Symposium on Intellectual Property, is held annually, alternating between inviting participants from China, Korea, and ASEAN countries, and from the US and Europe. This year, it is the Japan, China, Korea, ASEAN Forum, And I am very pleased that the symposium is being successfully held again this year with the participation of so many people. Lastly, I'd like to briefly introduce the basic concept in Japan regarding the theme of today's session, inventive step in AI and IoT-related inventions, for which there will be presentations by each country. So I'll briefly touch upon that in the Japanese context. As with other inventions, inventive step in AI-related technologies is a very important factor to be considered during examination and trial. The concept and method of determining inventive step for AI-related technologies are not particularly different from those for other inventions. This concept and the judgment method are summarized in a document called the Examination Guidelines. These guidelines summarize the concept and the judgment method of requirements for patentability, such as inventive step, based on trial decisions and judgments. As stated in the examination guidelines, in Japan, in determining inventive step, we make a comprehensive assessment of factors in support of the non-existence of inventive step and factors in support of the existence of inventive step. This will be the last slide. I'd like to introduce one specific trial decision on AI-related technology. For an invention related to industrial machining device, inventive step was denied for the invention that merely states that machine learning is used to adjust various parameters of machining conditions that have conventionally been done by humans, but does not specify the details of the machine learning. As written in the excerpt of the trial decision, the panel points out that there is a motivation to have the machine adjust the machining conditions based on the machining accuracy and machining time of the cited invention, because having the machine perform the learning that used to be performed by humans and adjustments that used to be made based on empirical rules will lead to labor savings and improved production efficiency. So various machining conditions, adjusting that by machines, well, there would be a motivation by persons skilled in the art. And the input and output parameters that the machines handle, they are just the same parameters that have always been used. And so having AI simply do what people have conventionally done by trial and error does not constitute an inventive step, as was the decision given. On the other hand, if there are uniqueness in how to prepare and utilize supervision or learning data, and there are advantageous effects found or teaching away, then inventive step may be admitted in many cases. So in the panel discussion to be held after this, we hope that you will keep this in mind as you listen to the discussion. And that concludes my presentation. Thank you very much for your kind attention.
Thank you very much.